I'm attorney Nick Alcock. I would like to speak a little bit about what to do if you get a summons in the mail and the summons says that you are facing felony charges and you have to go for your initial appearance. When you receive a summons in the mail, usually there's also a fingerprint order, and they say you need to go down to the sheriff's department, get your fingerprints taken, and then show up for that initial appearance. This is a very, very scary thing to get in the mail, obviously, and you're facing felony charges if you do get one of these in the mail. And it's very concerning because you don't know what's going to happen to you when you go to court. And one of the reasons why you don't know what's going to happen to you is that the judge could impose a variety of release conditions. And it's basically completely up to the judge. The judge can release you OR, which is on your own recognizance during the pendency of the case while the case is going on. The judge can release you to pretrial services, which is kind of like being on probation while the case is going on, or the judge could impose a bond. There are other certain types of cases where there really isn't bond available. Those are certain sex offenses and cases where a person doesn't have legal status. So there are definitely a wide variety of things that can happen to you when you show up for a summons. Now, what I can tell you is this, is that if you have been summoned, most of the cases that I see, people are either released OR on their own, where they don't have anything to do, no one to report to during the life of their case, or they're released to pretrial services, which is essentially maybe you have to submit to drug monitoring, urinalysis, and you have to meet with someone once a week, or at least call in once a week. That's the vast majority of the cases where you receive a summons. Now, there are other cases where someone receives one of those summons and then they find out that there's another warrant or there's some other action against them. Those people can be taken into custody. My advice to you, if you do receive a felony summons in the mail and you're concerned about what's going to go on, you got a little bit of time, call an attorney. You can call us at 602-989-5000. That's 602-989-5000. The call is absolutely free. We're more than happy to sit down with you, research your case, and figure out what's going on. As a criminal defense attorney, I can tell you that if you are facing a felony case, there's so much misinformation out there. And so many times people will come to me and they'll think, well, I'm definitely going to go to prison. But then I look at the case and I figure that no, this is actually just a drug possession case where jail and prison really isn't even a possibility. Or there might be a way to get a very quick diversion deal where you won't even wind up with anything on your record. There are other cases that are usually charged as felonies, but then they wind up almost always getting converted into misdemeanors or undesignated offenses. An undesignated offense means once you complete probation, it becomes a misdemeanor. So the fact that you're charged with a felony does not mean that your life is over. It doesn't mean that there's no hope for you and your future. It just means that you need to educate yourself. This obviously is a very, very serious thing, and you need to keep that in mind. And when you go to court, you should have information. 602-989-5000 is our number. Give us a call. More than happy to walk you through the process, help you better understand what it is you're facing. Thanks so much.